Good evening, everyone. I'm Professor Michelle Foster, the Dean of Melbourne Law School, and it is such a pleasure to welcome you to the 2026 Melbourne University Law Review Annual Lecture. I'd like to begin by acknowledging that we are gathering this evening on the unceded lands of the Wurundjeri people of the Kulin Nation, and I pay my respects to Elders past, present and emerging, and extend that respect to all First Nations people who are joining us this evening. I'd also like to acknowledge our wonderful guest speaker for tonight, Justice Bromberg. It is such a pleasure to co-host this evening alongside the Melbourne University Law Review and to partner with editors Olivia Mann, Lucy Roberts-Lovell and Alex Robertson, who of course are students here at Melbourne Law School. The Melbourne University Law Review is one of the leading peer-reviewed journals in Australia, publishing high-quality contributions across a wide range of topics in the form of articles, case notes, book reviews and review essays. The review is managed by an editorial board comprising students of the Melbourne Law School. And so therefore, the review is a powerful example of student contribution shaping legal thought. Previous editors of the review have gone on to become leaders of the profession, and we are so proud to count them as part of our alumni community. I'm deeply grateful to all student, professional and academic contributors to Melbourne University Law Review, as well as my sincere thank you to its current editors, Olivia, Lucy and Alex, for their stewardship of our law school's important contribution to the global tradition of student-managed publications. We will also welcome Lucy later on to close out the evening with a vote of thanks. And now I will shortly hand over to my law school colleague, Professor Andrew Godwin, to introduce our speaker. Professor Andrew Godwin is Professor of Commercial Law at Melbourne Law School and Associate Dean, Melbourne Law Masters. Andrew also served as Special Counsel and Acting General Counsel at the Australian Law Reform Commission from September 2020 to February 24. There will be a chance at the conclusion of the lecture for you to ask questions, and Andrew will also moderate the Q&A. But now it's my pleasure to hand over to Professor Godwin. Thank you.
Thank you, Dean, and good evening, everyone. It gives me great pleasure to introduce our speaker for today's lecture, the Honourable Justice Mordecai Bromberg. It's always a privilege to welcome judges to Melbourne Law School. In fact, as Your Honour may have heard, the Law School yesterday had the privilege of welcoming your predecessor at the Australian Law Reform Commission, the Honourable Michael Kirby, who was the inaugural president of the ALRC, or chairman, as the position was then known, when it was established in 1975, 50 years ago. For me, today's opportunity is a special privilege because, as the Dean mentioned, Justice Bromberg and I were colleagues at the ALRC between July 2023, when Justice Bromberg was appointed President, and February 2024, when my term came to an end. The 18 months or so that Justice Bromberg and I spent together were unforgettable, for all the right reasons, I'd like to add. And I look back with very fond memories of all the things we did together, whether it be working on inquiries, dealing with the bureaucracy, or collaborating with our fantastic law reform colleagues, including the commissioners who were appointed to support specific inquiries, and also the part-time commissioners appointed for a term of years to assist the ALRC on a general basis. And I'd like to acknowledge two of the general part-time commissioners who supported the ALRC during my time there, the Honourable John Middleton, who at the time was a judge of the Federal Court of Australia, and the Honourable Justice Mark Mizzinski, who is a current judge of the Federal Court and is still serving in the role of part-time commissioner at the ALRC. I'd also like to acknowledge colleagues at Melbourne Law School who have served as inquiry-specific commissioners at the ALRC at various times during its history. These include Professor Hilary Charlesworth, Professor Helen Rhodes, who served sometime as acting president of the ALRC, Professor Jenny Morgan and Professor Lee Godden. So, turning to our guest speaker, by way of brief introduction, Justice Bromberg has had an incredibly illustrious career to date, including as a member of the Victorian Bar and also as a judge on the Federal Court of Australia, a role in which His Honour has served since 2009. Justice Bromberg is therefore one of our most senior Federal Court judges. Among many other honorary positions that Justice Bromberg currently holds is Chair of the Advisory Board of the Centre for Employment and Labour Relations Law at Melbourne Law School. And no mention of Justice Bromberg would be complete without noting the time that he spent as a consultant to the ILO, an occasional consultant to the International Labour Organization. And also, just to complete the story, the time that His Honour spent in his youth. You knew this was coming, didn't you? When he played 4 seasons of Australian rules football for the St Kilda Football Club. A rare distinction that, to my knowledge, is unmatched by any other Australian judges to date, and I would hazard a guess will remain unmatched by any Australian judges in the future. Looking back, it's difficult to believe that Your Honour has now served almost 2 years as President of the ALRC. A lot has happened in that time, if my understanding is correct. 4 inquiries have been completed and 2 inquiries are currently underway. In today's lecture, Justice Bromberg will reflect upon Australia's international law obligations and the role that international law and human rights play in the development of Australian law. Justice Bromberg will also discuss law reform in Australia and the work of the ALRC. Following the lecture, we hope to leave some time for Q&A, and I'll join Justice Bromberg at the front to take questions. And then I'll hand it over to Lucy to close the evening and deliver a vote of thanks to our speaker. So please join me in welcoming Justice Bromberg to the lectern.
Well, good evening. Firstly, can I thank both Michelle and Andrew for their kind introduction, and also thank the board of the Melbourne University Law Review for their kind invitation. I'll have to correct you. I'm not the first judge that's ever been an AFL footballer, but I think I'm the only living judge. May I begin by acknowledging the Wurundjeri people as the traditional owners upon the land on which we meet, and extend my respects to their elders, past and present. Acknowledging traditional owners, I've always thought, is important. It brings to the fore of my mind the past injustices inflicted on our First Peoples and the consequent need for reconciliation and repair. And it is to that issue that I now want to turn. Now, can we get the map up? Yes, thank you. Here is a map of a continent that I suspect you'll all be quite familiar with. What was the greatest injustice that was ever inflicted on the peoples, the occupiers of this continent? And what was the legal concept that was used to justify it as lawful? Well, I think you probably all know the answer to that question. No injustice in the history of this continent is graver than the law which took the lands and waters of the continent from its rightful owners. But how did that happen lawfully, and what, if any, role did international law play? Terra nullius is a Latin expression meaning land belonging to no one. Some of you might be surprised to learn that terra nullius is a concept born of international law rather than of our common law. It was developed by colonising European nations in the 18th and 19th centuries. Under 18th century international law, there were 3 methods of acquisition of sovereignty over a new territory: conquest, cession, and occupation of a territory that was terra nullius. The concept of terra nullius was applied expansively. It was not confined to uninhabited territory, but enlarged to include territories inhabited but by what was referred to as backward peoples. A derogatory term and a notion based on nothing other than the discriminatory idea that Europeans were civilised whilst Indigenous people were barbarians, low in the scale of social organisation, with no laws and no rights to property. The English common law became the law of the colony of New South Wales in 1788 and the law of each subsequent Australian colony. In step with international law's concept of terra nullius, an expanded interpretation which included inhabited territory of backward peoples, the law of the Australian colonies and subsequently the common law of Australia presumed that First Nations people held no property rights and the Crown's sovereignty over the Australian continent, acquired under the enlarged notion of terra nullius, was equated with Crown ownership of the lands thereof. So here we have a critical contribution made by international law to the very foundation of Australia as a nation state. A contribution that was used to legally justify the greatest injustice inflicted on the peoples of our continent. A stain on our civilisation, the consequences of which persist, including in our current laws. Look again at the map of Australia. The green on that map depicts the country where native title has now been recognised. About 64% of Australia's landmass is now subject to a determination of the Federal Court which recognises the traditional rights and interests of traditional owners over their land and waters. That percentage will likely grow. There are native title determination applications yet to be made or yet to be resolved. Native title is a property right created and conferred by the Native Title Act 1993 Commonwealth, an act enacted in response to the High Court's decisions in Mabo. It is notable, as Justice Michael Kirby has observed, and I quote, that Australia enjoyed 150 years of elected representative government and not a single parliament of our nation saw fit to reverse the manifest fiction that Australia was terra nullius when settlers first arrived. It was left to the High Court in Mabo to shatter the fiction and propel our country to a just law. The reform of our law brought about by Mabo and then reflected in the Native Title Act is, I would argue, the most important law reform exercise our country has ever witnessed. Whilst the reform did not reverse the entirety of the injustice it afflicted on First Nations peoples, it was nevertheless breathtaking in its scope and bold and courageous in its objective. Notably for the theme I am here developing, the High Court's reconsideration in Mabo number 2 of the concept of terra nullius was in part predicated on an advisory opinion of the International Court of Justice, in which the court considered the concept of terra nullius and whether it extended to inhabited land. In the leading judgment in Mabo number 2, Justice Brennan construed the ICJ opinion as excluding inhabited land from the concept of terra nullius. His Honour concluded, and I quote, "If the international law notion that inhabited land may be classified as terra nullius no longer commands general support, the doctrines of the common law which depend on the notion that native native peoples may be so low in the scale of social organisation that it is idle to impute to such people some shadow of the rights known to our law can hardly be retained. In other words, if the fiction which treated the rights and interests in land of Indigenous inhabitants as non-existent was now discarded by international law, the fiction could have no place in the contemporary law of Australia. The other contribution made by international law which enabled this breathtaking reform, and which is perhaps less well understood than the rejection in Mabo of the concept of terra nullius, is the application of Article 5 of the International Convention on the Elimination of All Forms of Racial Discrimination. International human rights law is premised on the idea that all persons are inherently equal, and that the right to equality before and equal protection of the law requires that the law neither discriminate against nor fail to protect from discrimination any person or people. Discrimination on the basis of race has assumed a particularly prominent position in international law, with the prohibition on racial discrimination emerging as a peremptory or just cogence norm, that is, a norm from which derogation is never permitted. The International Convention on the Elimination of All Forms of Racial Discrimination is the predominant international law instrument concerned with discrimination on racial grounds. Amongst other things, Article 5 of ICERD guarantees, without distinction as to race, the right to equality before the law in relation to the enjoyment of a number of enumerated rights, including the right to own property alone as well as in association with others. Australia is a party to ICERD and has incorporated its obligations into domestic law by way of the Racial Discrimination Act 1975 Commonwealth. In particular, Section 10 of the Racial Discrimination Act enshrines the right to equality before the law, including in relation to the right to own and enjoy property without discrimination. As a High Court majority in Commonwealth and Yunupingu recently stated, the motivating rationale of Mabo number 2 was to ensure that all persons, including native title holders, are equal before the law in the enjoyment of their human rights to own and inherit property. It was by reason of Article 5 of ICERD and its adoption in Section 10, subsection 1 of the Racial Discrimination Act that the majority in Mabo number 2 concluded that a state law which sought to extinguish traditional native title would fail because Section 10, subsection 1 of the Racial Discrimination Act, and I quote, clothed the holders of traditional native title with the same immunity from legislative interference with their enjoyment of their human rights to own and inherit property as it clothes other persons in the community. As I hope you can see, international law has its fingerprints all over our nation's greatest legal controversy. International law bears some responsibility for the problem and for its solution. For the most atrocious injustice inflicted and for the most courageous and breathtaking law reform ever undertaken by our courts and our parliaments. The significance of international law to Australian domestic law is otherwise well demonstrated. International law is used by our courts to inform the interpretation and content of legislation. Legislation is to be, and I quote, interpreted and applied as far as its language admits, as not to be inconsistent with the Comity of Nations and with established rules of international law. And I'm quoting the High Court in Kingdom of Spain and Infrastructure Services, Luxembourg. Human rights norms also inform the rights and freedoms which the common law regards as fundamental and in relation to which the rule of statutory interpretation known as the principle of legality will operate. Furthermore, in Maba No. 2, writing with the concurrence of Chief Justice Mason and Justice McHugh, Justice Brennan said this: "The common law does not necessarily conform with international law, but international law is a legitimate and important influence on the development of the common law, especially when international law declares the existence of universal human rights." Additionally, international law provides the Commonwealth Parliament an important source of its constitutional capacity to enact legislation. The environmental legislation made pursuant to the World Heritage Convention, which led to the Tasmanian Dams case, illustrates the significance to the Australian polity of the external affairs power under our Constitution. Utilising its external affairs power, the Commonwealth Parliament has brought into our domestic law important human rights protections, though mainly directed at particular fields such as discrimination law. The Racial Discrimination Act, the Sex Discrimination Act, the Disability Discrimination Act are illustrative of important reforms sourced in Australia's international obligations. In the economically significant field of industrial relations, conventions and recommendations of the International Labour Organisation have been variously brought into our domestic law. That primarily occurred in 1988 through the wholesale reform of what was then the Industrial Relations Act 1988, when Australia moved from an industrial relations system based on conciliation arbitration to a system predominantly based on collective bargaining. These reforms included the introduction of a right to strike, as well as protections for employees against unfair dismissals. Refugee law has also engaged with and been reformed by reference to Australia's international legal obligations, but the extent of Australia's compliance with those obligations is contested. Despite the very substantial reforms in particular fields of the law, Australia's international law obligations are only negligibly reflected in our domestic laws. Unrepresented in our domestic laws are many, if not most, of the human rights enshrined in the International Covenant on Economic, Social and Cultural Rights and the rights enshrined in the International Covenant on Civil and Political Rights. That international law should have some influence over Australia's domestic law is, I think, uncontroversial. What is more contested is the extent of the significance that international law should have on our domestic law. Many would contend that in a representative democracy, the law's adherence to international human rights is a necessary check and balance upon the potential for majoritarian rule to override the rights and interests of minorities. Others would complain that the imposition of human rights norms on our domestic laws involves the loss of sovereignty as well as provides excessive power to unelected judges at the expense of our elected parliaments. These are competing views reflected in the debate as to whether Australia should have a Bill of Rights. That's not a debate I have either the time or capacity to further canvass this evening. Thankfully, the position which the Australian Law Reform Commission must take in relation to the significance to be given to international law is relatively clear. The Australian Law Reform Commission's Enabling Act requires that in performing its functions, the ALRC must aim at ensuring that the recommendations for law reform made are, as far as practicable, consistent with Australia's international obligations. Consistency and compliance with Australia's international legal obligations, whether or not those obligations form part of our domestic law, is a mandatory objective for the work of the ALRC, qualified only by the need for practicability. That requirement may be contrasted with the requirement made upon the Commonwealth Parliament by the Human Rights Parliamentary Scrutiny Act 2011, which only requires that every bill be accompanied with a statement of compatibility which assesses the bill's compatibility with human rights. In addition to the obligation imposed by the ALRC's Enabling Act, it is common for terms of reference for ALRC inquiries to specifically request that the ALRC consider particular international instruments, including from time to time international instruments such as UN declarations which are not binding on Australia, but which Australia has endorsed. In the relatively short time, some 2 years, in which I've been at the helm of the ALRC, international law has been at the forefront of the principles and doctrines which have guided our work and the recommendations for law reform which we have or are about to make. Let me tell you something about that. In December 2023, the ALRC published a report dealing with the exemptions given to religious educational institutions by the Sex Discrimination Act and the Fair Work Act. Those exemptions allow religious educational institutions to lawfully discriminate against their students and against their staff on the basis of sexual orientation, gender identity, marital or relationship status, or pregnancy. That inquiry required consideration of some 10 different human rights sourced in a wide range of international instruments. The most significant of those were the right to freedom of religion and the right to equality and freedom from discrimination. I'll come back to that inquiry shortly. In January 2025, the ALRC published a report on reforming the justice system's responses to sexual violence. The ALRC considered a wide range of international obligations arising from some 5 conventions and various UN declarations, including primarily the Convention on the Elimination of All Forms of Discrimination Against Women. Just this month, the ALRC completed a yet-to-be-published report on what is known as the Future Acts regime in the Native Title Act. The Future Acts regime is the system within the Native Title Act that regulates when native title property rights and interests can be lawfully infringed by, broadly stated, acts of government or acts permitted by government, such as the granting of mining tenements or pastoral leases. A central consideration in that inquiry was whether the Native Title Act itself is out of accord with Article 5 of the Convention on the Elimination of All Forms of Racial Discrimination by denying to native title holders equality before the law because, under the Future Acts regime, the Act treats native title as an inferior form of property when compared with freehold or ordinary title. Now, I can't tell you our finding because the report hasn't yet been tabled in Parliament, and it's not public, but can I just say it'll make for some interesting reading. Our inquiry into Australia's surrogacy laws will consider and aim to ensure compliance with the Convention on the Rights of the Child. The rights of the child include a right to be safe and free from harm and exploitation, a right to be cared for by their parents, as well as a right to privacy, family and home. Whether and how those rights, as well as the prohibition on the sale of children, are able to be respected in the context of a child born of a surrogacy arrangement raise complex issues which are much contested. By reference to various international conventions, in that inquiry, consideration is also being given to the rights of a surrogate to be free from harm, exploitation, discrimination, and the surrogate's right to autonomy and bodily integrity. Additionally, consideration is being given to the rights of intending parents, including as to whether the right to found a family, a right which emanates from the International Convention on Civil and Political Rights, is applicable. Lastly, our current inquiry into Australia's human tissue laws also raises important human rights considerations. This inquiry largely deals with the regulation of organ donations, the donation and use of human tissue for research and medical purposes, and the storage and importation of human tissue. All of those applications or uses of human tissue raise concerns about respect for the human body and the dignity of the human person, and in particular, concerns about the commodification of the human body and the potential exploitation of people who provide their tissue. The inherent dignity of the human person is a foundational human rights principle recognised by the Universal Declaration of Human Rights, amongst many other international instruments, including the International Convention on Economic, Social and Cultural Rights. That convention also brings into consideration the right to health and the right to benefit from scientific progress. As you can see, or at least as I hope you can see, the ALRC is blessed with the privileged task of giving consideration to a tapestry of fundamental rights. Each of those rights is never considered in isolation, and the tapestry is rarely dull or straightforward. Rather, we usually face a complex, rich mixture of rights to consider. It is commonly the case that one or more human rights under consideration are in apparent tension with one or more other rights. Some of the most interesting and often the most controversial part of our work requires us to reconcile rights in apparent tension. Let me turn to an example to illustrate both the problem and the mechanism we use to resolve it. A good example is the inquiry I mentioned earlier into religious education institutions and the exemptions provided to religious schools which allow for discrimination on sexual orientation, gender and related grounds. Stakeholders with whom we consulted who supported the removal of the exemptions argued that the exemptions infringed one or more of the following human rights: the right to equality and freedom from discrimination, the right to work, the right to education, including children's rights with respect to education, rights to health and life, right to privacy, right to freedom of expression, right to freedom of religion, right to parental liberty. That's the right of a parent to choose an education for their child. On the other hand, those stakeholders who supported the status quo expressed fear of and resistance to the removal or diminishment of the exemptions provided to religious educational institutions and advocated in support of retaining their capacity to build and maintain a community of faith in their schools. They relied upon the right to freedom of religion, parental liberty, the right to freedom of expression, and the right to freedom of association. To add to the complexity, as you might have noticed, some of the rights in question, such as freedom of religion and parental liberty, were on both sides of the debate. The problem that we faced was a human rights problem, and in resolving it, the ALRC turned to the mechanism used by international human rights law to address rights which appear to be in conflict. That mechanism has as its purpose the aim of maximising the realisation of human rights. The mechanism employed is based on an understanding that all human rights are equal. There is no hierarchy. There is no ranking. One human right does not overrule another when they seemingly conflict. That is because all human rights are universal, indivisible, interdependent, and interrelated. They belong together and are designed to work in unison so that each accommodates the other. Only a small number of human rights are absolute. Freedom from torture and freedom from slavery are examples. The protections that they provide can never be infringed because torture and slavery are so abhorrent that they can never be justified in the name of religious freedom or in the name of any other human right. All other human rights are qualified, meaning that they can be subjected to lawful limitation. This can be seen to arise from the very framework for human rights, which, as affirmed in the 1993 UN Vienna Declaration and Programme of Action, conceptualises human rights as coexisting and reinforcing because they are universal, indivisible, interdependent, and interrelated. In simple terms, this means that human rights are designed to live together, one in harmony with the next. Accordingly, each human right needs to be understood as tolerating a legitimate limitation upon that right imposed by the need to respect the substance of each other human right. And by every human right so accommodating the next, although human rights may sometimes seem to be in conflict, in truth they never are. Respect and tolerance provide the tonic for human rights to maintain an enduring equilibrium and for the holders of human rights to harmoniously enjoy the freedom, justice and peace that human rights systems aim to provide. The realisation that one human right must tolerate and accommodate another is probably the easy bit. What is more difficult is the extent to which one right must accommodate another. Here we enter somewhat of a grey zone, which requires a great deal of attention to be given to the usually bespoke context in which one right intersects with another. International human rights law again provides us with some guiding principles. It is those principles which provide the criteria or the mechanism for resolving the extent to which one human right must tolerate or accommodate another. That mechanism has often been conceptualised as involving the need to balance one human right against the other. However, the metaphor of balancing has been criticised, and the language of maximising the realisation of human rights is now preferred by many. That language, I think, better accords with what is the object of the exercise of mutually respecting and accommodating intersecting human rights, namely to maximise the enjoyment by all affected of their rights to be accorded dignity. The guiding human rights principles begin with the appreciation of the need for a compelling justification when a limitation is imposed upon the full application of a human right. So much is reflected in what are known as the Syracuse principles adopted by the UN to deal with limitations upon the rights conferred by the International Convention on Civil and Political Rights. Any limitation on a human right must be provided by law, pursue a legitimate goal, be necessary and be proportionate to the specific need it is aimed at addressing. Applying that limitation criteria is more complicated when multiple human rights intersect. That is so because the legitimate limitation on one right must be considered by reference to the legitimate limitation that may be imposed on the other. The reconciliation required must be done by preserving the substance of each of the intersecting human rights to the maximum degree possible. Here then is the key principle for respecting and accommodating one right with the next. The substance of each right must be preserved. This requires that the substance of each intersecting right be identified. That, I think, involves asking, what is the core content of the right? What is at the core of each of the intersecting rights is then to be protected to the maximum degree possible. By core, I don't mean critical, but I do mean of central importance. In the Religious Educational Institutions Inquiry, the ALRC ultimately concluded that each of the principal human rights in question, freedom of religion and freedom from discrimination, had, to some extent, to be limited so that the substance of each right was preserved, thus maximising those intersecting human rights to the greatest degree possible. By that exercise, the primary conclusion reached by the ALRC was that the exemptions from the prohibition on discrimination given by the law to religious schools overreach. They go further than it is necessary to protect that which is at the core of the right to manifest religion in community with others, namely the capacity to build and maintain a community of faith. Fascinatingly complex issues of that kind are currently occupying the ALRC's thinking in relation to both our surrogacy inquiry and our inquiry into Australia's human tissue laws. Long may that continue. It is challenging but interesting work, which I greatly enjoy. But will it continue? In the context of the current challenges faced by the rules-based international order, will Australia's international obligations continue to have a role in the reform of our domestic law? Should the budding international lawyers, which I presume I am mainly speaking to this evening, be concerned that a career in international law may be an evaporating ambition? For this part of the lecture, may I acknowledge and extend my gratitude to this university's distinguished expert on public international law, Professor Anne Orford. I've borrowed extensively from Professor Orford's writing on this topic, as well as her recent presentation to the judges of the Federal Court. Professor Orford's view, with which I respectfully agree, is that international law is currently undergoing a period of transformation. As Professor Orford has observed, in contrast to the post-Cold War period of great ambition in international law in the 1990s, fostered by what was then the monolithic United States of America, a period of transformation began in the first decades of the 21st century. That transformation began with the resurgence of a more assertive Russia, the economic growth of China, and the emergence of the BRICS group of countries and other South-South alliances as significant players in the development of international law. Whilst that period of transformation was not initiated by the US, it has been greatly accelerated by the current US administration. Let me give you some examples. The international law regime for international trade has been significantly repudiated by the US. Since 2011, the US has blocked the appointment of members of the World Trade Organization's appellant body, and that body ceased to function after 2019. Since 2025, bilateral and multilateral trade agreements, as well as the international trading system itself, has been undermined by the unilateral imposition by the US of waves of tariffs. Both the US and Russia have sought to subvert the capacity of the International Criminal Court to carry out its functions. The US has imposed sanctions on any person assisting the ICC in investigating, arresting, or prosecuting US personnel or those of its allies without consent. To date, 8 ICC judges, a prosecutor and 2 deputy prosecutors, have been subject to sanctions which include bans upon them from travelling to the United States, the freezing of their assets in the United States, as well as a denial of access to American products and services, including internet-based financial services. Imagine waking up one day and having your MasterCard cancelled simply because you're a judge of the ICC. In 2024, Russia issued arrest warrants against ICC staff and conducted cyber attacks against the ICC in response to arrest warrants for President Putin and other Russian officials. In December 2025, Russian courts convicted in absentia an ICC prosecutor and 8 ICC judges and sentenced them to imprisonment on charges related to the unlawful prosecution of Russian citizens. In relation to international instruments and institutions addressing climate change, the US has withdrawn from the Paris Agreement and from the UN Framework Convention on Climate Change. Financial commitments made by the US and pledges of funding for the UNFCCC Green Climate Fund have been rescinded. The US has also pressured other states not to vote for the adoption of a net zero framework by the International Maritime Organization. Pressure was applied on Vanuatu to withdraw its pursuance of a resolution of the UN General Assembly for an advisory opinion to be obtained from the International Court of Justice on the legal consequences of climate change. In March 2026, the US Energy Secretary threatened the withdrawal of the US from the International Energy Agency unless that institution abandoned its climate focus. Worse still, in February of 2025, President Trump signed an executive order directing the US Secretary of State to conduct a review of all international organisations and treaties to which the US is a party and to determine which are contrary to US interests. The US also ended funding to the UN Human Rights Council. In January 2026, the US announced its withdrawal from 66 international organisations, including the Intergovernmental Panel on Climate Change, the International Renewable Energy Agency, the International Union for Conservation of Nature, the International Law Commission, and, as I say, a large list of 66 such institutions. These events are understandably alarming for the international lawyer. They probably do spell the end of the 1990s rule-based order, but it seems far too early to declare the inevitable death of international law. The apparent loss of faith in international law and its institutions by the US may well be only transitory. Notably, the vast majority of other nation states have shown no inclination to follow the lead of the US. Furthermore, there are at least some isolated indications that point to the potential for international law to expand rather than contract its influence. On 23 July 2025, the International Court of Justice published its advisory opinion on the obligations of states in respect of climate change. The opinion, quite remarkably I think, is a unanimous decision of a 15-member court. As you know, a court comprised of judges from all over the world. In unequivocal terms, the ICJ opined that states owe a duty under customary international law to prevent significant harm to the Earth's climate system. The ICJ also concluded that the human rights to a clean, healthy and sustainable environment are inherent in the enjoyment of other human rights and essential for the enjoyment of other human rights. The duty recognised by the ICJ extends to requiring states to use all available means to prevent activities causing climate-based harm, including the regulation of private operators within a state's jurisdiction. The ICJ identified fossil fuel production, fossil fuel consumption, the granting of fossil fuel exploration licences, and the provision of fossil fuel subsidies as conduct that may breach a state's international law obligations and constitute an internationally wrongful act. The court observed that an internationally wrongful act would expose states to the entire panoply of legal consequences, including orders requiring cessation or non-repetition of harmful activities, as well as full reparation by way of compensation or other redress. That means that a state that has accepted the compulsory jurisdiction of the ICJ may claim the full range of available remedies, including compensation, against another state, a state like Australia that has also accepted the ICJ's jurisdiction. The ICJ's opinion appears to be an open door to very substantial litigation before the ICJ. Alongside the advisory opinion of the ICJ, a growing body of authority on states' international legal obligations with respect to climate change, including recent advisory opinions of the Inter-American Court of Human Rights in 2025 and the International Tribunal for the Law of the Sea in 2024, and case law by the European Court of Human Rights, has emerged demonstrating growing recognition by international law of the climate crisis. Furthermore, although the ICJ advisory opinion is non-binding, it can be expected to carry significant weight and may be expected to influence not only national climate change policies and international agreements, but also domestic climate change litigation. However, Whether or not the events I've mentioned are transitory or isolated, the fact that international law is in a period of transition seems to me to be undeniable. There are primarily two changed circumstances which underpin this transition. The first is geopolitical and based on the fact that with the ascendancy of China, we are moving from a unipolar to a multipolar world, a world more akin to that of the Cold War period. The second changed circumstances is that we are moving from a relatively stable natural world, upon which various aspects of international law are based, to an unstable natural world, which will precipitate a reconsideration of how human civilization is to be organised, including under international law. As Professor Orford has observed, change should not necessarily be regarded as scary by the international lawyer, including the budding international lawyer. Changed circumstances, I should tell you, are the bread and butter of law reform, and significant law reform, including of international law itself, may well now be in prospect. That reform will require the services of skilled and proficient international lawyers of the kind that this university has an enviable reputation for producing. Thank you for listening.
Good evening, everyone. I'm Lucy. I'm one of the editors of the Law Review this year. And on behalf of my co-editors, Liv and Alex, there are a great many number of people that I'd like to thank tonight. The first is the Melbourne Law School events team, in particular, Emily Holt. This is our third year running the annual lecture in collaboration with the events team, and they ensure that everything runs far more smoothly than we ever could and have really boosted the broader law school community's engagement with the annual lecture. I'd also like to thank Justice Bromberg's Executive Assistant, Dakota, for her assistance, and it was lovely to meet you today in person after over 3 months of email correspondence. To the Dean of Melbourne Law School, Professor Michelle Foster, thank you not only for your opening remarks at the lecture today, but also for your support of the review and our continued collaboration with Melbourne Law School events. We really appreciate it. Thank you to Professor Andrew Godwin for introducing Justice Bromberg this evening and moderating the Q&A session. Professor Godwin very kindly agreed to this at short notice as our original moderator was unfortunately unwell today, so we are very grateful to have you helping us. And finally, for the most important thank you of the evening, Justice Bromberg, we sincerely appreciate Your Honour taking time out of your very busy schedule to address us tonight on such an interesting topic. We received so many registrations for this lecture that we had to move it to a bigger lecture theatre than previous years. And I think that's a testament to the fact that Your Honour's address was of such great interest to many people from all facets of the legal world and to the timeliness of this topic. It can be difficult as law students to learn very much in the abstract about both Australian and international law, and then to look out in the world and see a very different reality. Your Honour's lecture deftly dealt with issues that are on all of our minds as law students, legal academics and practitioners. It left us with much to think about, and dare I say it, some hope. So thank you very much, Justice Bromberg, and thank you to all of you for coming, and we hope you have a lovely evening.